boosters.
Right. Okay, we'll begin with the second case is In re Bozeman. So if welcome to the Court of Appeals, and if you're ready, we'll hear from the appellant and let us know if you want to reserve any time for rebuttal.
Thank you, Your Honor. I'd like to reserve 3 minutes.
You said 3?
Yes, sir.
3 minutes, perfect. Well, we got the clock, perfect.
May it please the court, my name is Jason Page. I represent the appellant, Sage Huddleston. The trial court found that Sage had abandoned her husband, Matt, and is therefore barred from inheriting. This court should reverse that judgment because the findings of fact don't support the conclusion of abandonment. This started as a motion before the clerk, and the sole basis of that motion was abandonment under 31A-1A3. Under that statute, Sage would be barred from inheriting if she willfully and without just cause abandoned and refused to live with Matt and was not living with him at the time of his death. So we have to look at the case law to know what abandonment means. And this court did that in the state of Metz in 2020. And the court said that marital abandonment occurs when a spouse brings the cohabitation to an end without justification, without the consent of the other party, and without the intent of renewing it. So we know that willful means without just cause, and then without just cause is part of abandonment. So you can interpret that statute to say a spouse loses the right to inherit as well as other marital rights under Chapter 30 when he abandons the other spouse and is not living with the other spouse at the time of death.
I want you to focus on the word cohabitation for me, because that was an issue for me. They had an agreement that they would live in separate houses. Does that mean that that was a different kind of cohabitation?
I think that meant there was not cohabitation. They married in 2018. They were married for almost 4 years when he died. They never lived together. The court found that there was never a marital home. The court found that upon return of from the honeymoon, Sage continued to live in Florida and Matt continued to live in North Carolina. And there are some differences between marital rights upon divorce or the end of a marriage while you're living and marital rights upon death, but there are also a lot of similarities, and this court chose to adopt that definition in 2020, and it is from the Panhorst case from 1971. But the court, there's a footnote in the Metz case that said they understood that and were applying it anyway. And it cited a couple of other 31A cases where there were this same definition applied. So they did not cohabitate. The cohabitation could not therefore come to an end. The argument to affirm this case, you'd have to say that's cohabitation is something different than what we've known before. The argument that cohabitation...
Should our case law be somewhat elastic with what cohabitate means for different marriages? Different relationships that people choose to enter to, how they're going to go about performing the marriage contract?
Well, I think...
Why should only people that choose never to live together to begin with can't abandon the marriage? That would insulate both parties at all times.
I think you get to a problem of what does abandonment mean if there's not cohabitation to begin with, because if you change that to something like they separated, one party calls the other to be separate from the other. Well, who gets to choose? I mean, these parties can choose to live separately. And, the abandonment, it stacks on end and brings the cohabitation to an end. So you have to do that without justification, without the consent of the other party, without the intent to renew it. And we also have a statutory definition of abandonment. It's in Chapter 50. Dwelling together continuously and habitually. And so if you choose to live separate, that just means you can't fit into abandonment. And that's what's happening here is we're trying to take a square peg and put it in a round hole. And it's just, it doesn't fit because that would have the impact. If you said, well, if you never lived together, then somebody, whoever dies first, the other party abandoned them. I mean, we can't have that. But that's what the appellee is asking you to do, is to add something to chapter 29 or chapter 30, where you have to have marriage to inherit. And I know there's nothing that's real clear when you get to the Court of Appeals, but I think it's pretty clear that marriage is what gives you those rights. When you get married, you have a right of intestacy under chapter 29. You have a right to an elective share under 30. You have a right to a year's allowance. And the only way you lose that is you do something in 31A, or you waive it through a premarital agreement or a separation agreement or a postmarital
Tell me again,
agreement.
what does abandonment mean under our case law? What do you have to do to abandon? What constitutes abandonment?
It's bring cohabitation to an end without justification, without the consent of the other party, and without the intent to renew it. And that's been the law since 1971 at least. And even though it was...
So if my wife and I agree to separate and I die, she's still my wife and can inherit?
Yes, sir.
It's just if I just leave and she doesn't want me to leave and I die... No, or she died, I'm sorry. If she leaves me and I die, she gets nothing. But if I agree to let her leave me and I die, she gets half my estate, or I guess my estate or whatever intestate succession will allow.
Right, or you could write a will that took her out and she'd still have
If I have no will and my wife and I agree to separate and I die before we divorce, she's my wife, she gets whatever she gets. But if she leaves me without my consent and I die, she gets nothing. Nothing.
If she leaves you without just cause, without your consent, then and y'all don't have an intent to renew the relationship.
So you're saying there's no findings that say that she either left or left without just cause, or there was...
Right. In fact, there's actually a finding that that they never established a marital home. So I think the term abandonment means something completely different if you don't have to live together. But here, it ends up being that you impose an additional requirement on chapter 29 and 30. It's getting married plus living together. If you can abandon without living together. It's just impossible to do that based on 50-some years of case law. And if the legislature wanted to say you have to get married and live together, they could do that because they did that with abandonment. You have to abandon your spouse and not live together.
So you're saying, under the law, she could have, you don't have to live together for there to be an abandonment, though. Is that right?
No, I think you do. I think that every analysis of abandonment in the Chapter 31A, under divorce from bed and board, it all says the elements are bring the cohabitation to an end. And my question is then, if you say, well, we got married, but my spouse never moved in with me, whose fault is that? Who gets to choose? Here we have testimony that Sage said...
Well, a jury or fact finder would be able to make this determination of who's...
If you have an agreement that you're not going to live together, though, and Sage testified that he could always come live with her. Matt's mother, the appellee, testified that he voluntarily stayed here. Sage testified she never intended to live here. She intended to live in Florida. And then the argument is, well, she abandoned him by not moving in with him. And, in fact, the appellee argued that it wasn't it wasn't with consent.
So you're saying one of your arguments is it was impossible for her to abandon him because they never lived together.
Correct. And I think the whole definition of abandonment falls apart if you don't have to live together. It's just something different. You don't have to like it, but people are trying, and this is what happened in the Metz case. The facts were a little different, but the husband and wife had been separated for 16 years. There was physical abuse there. He actually had a domestic violence protective order against him from South Carolina. But in that case, she had actually filed for divorce twice, and they'd been separated for 16 years. And the trial court said, well, the time passed, so much time's passed, that has to be abandonment.
So if my wife and I live together and then she leaves me and abandons me, that's abandonment. But if my wife and I get married and she works in South Carolina, I live in North Carolina, we visit each other, I visit her every weekend, she visits me every weekend, and then she all of a sudden says, stop it, I don't want to ever see you again, whatever, and does the same thing that she did in my first scenario, there's no abandonment because we never lived in the same house?
Right, but I agree with that, but you have remedies.
That's what you're arguing.
You have remedies for that. That's why it's different than parental abandonment. I mean, a parent loses that right when they willfully forego all parental duties. But children are differently situated from their parents than spouses are. Spouses, they can get divorced.
Yeah, what if I snore and I live in a separate bedroom from my wife? Are we cohabiting or not? Even though we might visit each other's bedrooms.
Well, I think it doesn't matter for purpose of this statute because you have to be cohabitating. You have to have abandoned and not live together.
So am I living with her if I'm not in the same bedroom? If I'm living not in the same bedroom in the same house, I am cohabiting. You would say that's cohabiting.
I would for purposes of this statute. I don't know if I would, depending on who I represented in a domestic case. I mean, we know there can be constructive abandonment in a family law context. There can't be here. I don't know why the legislature did that, but they said you have to have abandoned and not be living together at the time of death.
So your position is there was no abandonment because they never lived together, therefore she should be able to still claim her marital interest in his estate.
Correct, but I'm also arguing that if there could have been abandonment, Matt's the one who abandoned her first because the court did find that he struggled with substance abuse during the marriage and had periods of sobriety
which is
relapse.
a type of constructive abandonment under Chapter 50. All the things that are outlined as the second prong, you find under Chapter 50 marital problems.
Correct.
With alimony claims. But you're saying we can't even get there because they never lived together.
Right. But if you do, I think Matt abandoned first.
And let me ask about that. You argue about the verbal and physical abuse of Sage. The trial court doesn't appear to have made findings related to that one way or the other. So what are we supposed to do with that on appeal, on if this actually happened?
Well, I think the findings don't support the conclusion of law, so you reverse.
Well, if the findings don't include that anything resolving whether she was physically abused or verbally abused at all.
Well, he did. Judge Willie did acknowledge that the emails were disparaging.
But those are all appear to be after the time that's set for the date of abandonment in either, I think, July of 2019. These began in August, at least what was put into evidence.
Right, and I don't know where that...
I know she testifies that she was physically and verbally abused before this, but there's nothing in the record, or in the order at least, about that.
That's correct. There's nothing. There's a lot missing from the order from our perspective. I'm almost out of time. I'd like to reserve what's left and respectfully ask y'all to reverse. Thank you.
Yeah, thank you. And we'll give you 3 minutes. Thank you.
May it please the court, and thank you, Chief Judge Dillon and Judges Murphy and Judge Thompson for hearing this matter today. My name is Jordan Spanner. I represent the appellee, Pam Boyd, who is also the mother of the decedent, Matt Bozeman. I will, based on the court's questions just now, reverse my order of things a little bit and start with the issue of cohabitation. The appellant says that we want to expand the definition of the statute and the definition of abandonment and impose additional requirements. That's actually the flip of what's happening here. The appellant is the one who's asking the court to impose additional requirements that are not found in the plain language of the statute. Yes, this court and the Supreme Court have used a definition to explain what abandonment is, but that phrase, brings cohabitation to an end, is not found in the statute itself. And so there is no requirement in the plain text that cohabitation had to have existed and that it came to an end. That definition has been in the case law since 1971. It originated in the Panhorst case from the Supreme Court. In that case, the court was faced with different facts. The couple there had been married for 33 years, had lived together, and there's not been, at least that I can find, a set of facts similar to what we have here. Every time this definition has been used over the years, it is in the context of a marriage that has been ongoing for some time, and the couple lived together. The phrase that the court used, brings their cohabitation to an end, is descriptive. It's not prescriptive. And we can see that readily from the very next sentence in the Panhorst decision. The court gives this definition, brings cohabitation to an end, no intent to renew, no consent, and then the next sentence says, but wait, there can be constructive abandonment, that the couple doesn't even have to move out of the same home together for there to be abandonment. And so that paragraph alone lets us know.
So I'm looking at the order, and I'm struggling a little bit with the order. What findings are there that support abandonment? The only finding I see was that she said to somebody else the marital relationship had ended, but the court never finds she said it. It just says that she told, or that she believed it or they believed it. Would you just help me with the findings? What findings support a conclusion that there was abandonment?
Right. So
and that it was her fault and all this stuff, because they found that he sent disparaging message. I don't see any finding that even if it had ended, it was her fault without cause or whatever. I don't see that the court actually found that. And the finder of fact has to find that, unless it's in here. Tell me, I'm just looking at the order.
So in the findings of fact, the court points out that, let me find it in my highlighting. Despite her efforts to move.
Which finding are you in? I'm sorry.
Starting with, let's see, number 12, and some of this is just kind of, you take the facts all together. She had made steps to move to North Carolina by registering a motor vehicle, registering to vote. They had filed a joint tax return, but then you go, and that's in finding of fact 13. If you go down to finding of fact 14, the court notes the testimony from Ms. Boyd that says she learned in July of 2019 that the marriage between Matt and the appellant was ending based on conversations with both Matt and the appellant. And then
doesn't say it was against his will, so I still don't see that. I mean, they might be separating, but it's got to be she left him and he didn't want her to leave. So I'm still okay.
And then in finding of fact 15, it discusses those emails, the series of disparaging emails that came after she decided to leave him. If you look at those emails in the record, they are angry and they show that he was very unhappy with the situation. Fast forward a few more months, and the court notes this at the end of finding of fact 15, that in April of 2020, he sent another email apologizing and acknowledging that it says the content of the email shows that he believed the marital relationship had ended.
Let me ask a question about those emails real quick.
Yes.
If those had occurred before she actually left, would our case law have told us that her leaving was justified, that he had effectively abandoned her by that verbal abuse?
I think it would certainly change the facts. In this situation, because it happened after, we can't say that it justified her leaving in the first place.
But do we know that it only occurred after? We just have these findings that, there was this after conduct. There's testimony about verbal and physical abuse during the course of all these years of the marriage. I mean, do we have enough findings of fact to say that he didn't already abandon her before this?
Make sure I get my negatives right. I I don't think that that's the case. I think that, sorry, would you mind clarifying your question?
Sure.
Make sure I answer it correctly.
We have evidence post-July 2019 that the trial court acknowledges in the findings of fact of what arguably would be verbal abuse and would therefore probably cut off the fact that she could abandon him. Based on our case law, he would have abandoned her by using that language. But the testimony seems to be that this was occurring throughout the marriage, not just the exhibits. And I don't see a finding that this verbal abuse only started in August of 2019. If that verbal abuse had started all the way back when they were first dating, 2011, 2012, got back together, if it had just been happening throughout, wouldn't he have already, under our case law, effectively abandoned her?
Not necessarily. I think the relevant time period, I think a couple of things.
Okay.
One is the relevant time period would be from the time that they got married until the departure, we'll call it, whoever left who, that July of 2019. Yes, there is testimony generally that there had been incidents in the past. Their relationship spanned 2 decades. But my recall of the record, my read of the record, is there is no affirmative evidence of an incident that occurred in that time period. The other thing is that the trial court, as finder of fact, is entitled to weigh the evidence, determine the credibility of witnesses, draw reasonable inferences. The trial court's entitled to believe none, some, or all of witness testimony. And based on what we see in the findings of fact, the court apparently decided that this evidence, that this testimony about prior incidents of disputes in the home did not outweigh the other evidence in the case.
But this order is totally naked of any of what you just said. To me, it's just the judge is sitting there listening to the evidence and just simply reciting what he or she heard during the trial. It didn't make any it didn't refer to what impact it had on the court to then come to a finding of fact. It's just, I mean, even in number 5, it talked about she was aware of his substance abuse problems and his period of sobriety and his periods of relapse. Okay, so what? What does that do for the court? It doesn't end in a finding of fact. It just talks about the evidence that was heard and didn't come up with what does this now mean as a finder of fact. Even down to the point of just reciting what the mother found out. Like the mother was aware of something. Okay, so what? What does that mean for the judge? What does that mean for me as a finder of fact based upon all this evidence that was taken in?
Understood. And I think that it's taking all this evidence together, then the court reached the conclusion that there was abandonment and it was willful and without just cause. I don't know that there has to be a specific finding. The appellant, or I guess to use their names, Sage's testimony about the alleged abuse, I do not believe, but I do believe this other evidence. I don't know that a finding of fact has to be that explicit.
Well, not even that who the judge believed under those circumstances, but the impact that it had before you could even get to the conclusions of law. I mean, if the mother's testimony was based upon something she heard, something she observed, something Matt said to her, what impact did that have on this order? And it's just not there in the order. The order talks about, it's almost like it's blaming the wife. You knew about it beforehand, so why is it a big deal now that y'all are not together? But I don't even know that because it's not a real finding of fact. Does that make sense?
I understand Your Honor's point. I think there's also, again, it's bringing all these facts together, that there's also that finding of fact 16 that talks about the roommate who had not observed any violent behavior and that there had been no reason, he had not observed, let me find the exact statement. He saw nothing that indicated that Sage would not be safe living with the decedent. And again, I understand Your Honor's point that there's nothing explicit that says Sage was not unsafe, period. But I think taking all these facts together and then seeing the court's ultimate conclusion of law, the court's order is sufficient.
But it could also be the other way, taking all these facts together, as you say, she was justified. The relapse, the abusive language, the periods of sobriety, there was some reference to the reason that they wanted to get him out of North Carolina is because all of his drug friends were in North Carolina influencing him. But we don't know that because the order is empty.
I respectfully disagree that it's empty because we see the ultimate conclusion that the court reached.
Right, but that's a conclusion of law that we're going to have to redetermine, correct, de novo?
Right, and
How can we do that if we don't have findings of fact of what was going on before July of 2019? I know we've got this statement about the roommate in 2020 said no reason can be, that's after they were done. And it also, undercuts itself by saying also didn't see him using drugs. So what? She has already testified that it's when he's not sober that he's abusive. And, God only knows from what we see, people are the worst to the people that they're supposed to love the best. And, what he's doing behind closed doors is what's I'm seeing in the transcript, and I'm not seeing any resolution of it in this order for us to then say, okay, these things didn't happen. The trial court says there was no verbal abuse, there was no physical abuse before July of 2019, so I'm not going to say that she was justified to go, that he didn't effectively abandon her ahead of time. I just don't see how, from the findings of fact that we have here, we have enough to actually make our own conclusions of law on review.
so the issue of abandonment is a conclusion of law, but it is based on the totality of circumstances. And so yes, in the court's decision on this, the court is asked to look at all the factors, the totality of circumstances, to reach the de novo review of this conclusion of law. But the facts in the order are the ones that is the part that is binding on the court if it's unchallenged.
Right, but yes, I agree there. If it's unchallenged, it's binding on us. But if it's not sufficient enough, if there's things that are not resolved by the trial court for us to know the credibility, we can't make that determination right now. We don't even know that she was abused or verbally abused before August of 2019 at all, that any of this happened. So how can we, sitting here, make a totality of circumstances, take a look at this relationship, the abuse, the drug use, the relapse, the apology, everything, and say that she was justified or not justified when we don't know really anything from this besides they didn't live together and he was on drugs before July 2019.
So it comes from, again, let me make sure I'm answering the right question.
And I think we've probably given you 20 questions, but.
Yeah, no, it's totally fine. I just want to make sure I'm answering the right one. So, or answering them in a way that is going to make sense. Again, the court can I don't want to use the word reweigh because the court is not reweighing the evidence, but it's a totality of the circumstances. And I think that when we look at the findings of fact in the order, we can see what the trial court deemed to be credible, deemed to have weight, as opposed to the other things, the other pieces of testimony, the other evidence that was put on. And so even if there's not an explicit statement, this evidence outweighed this, or she was or was not abused before this date, we can still glean that from the findings of fact.
But the conclusions of law have to be supported by findings, and just to conclude that Sage willfully and without just cause, but where are the findings to match that when you're also talking about this relapse, the abuse, the fact that she wanted to get back with him if he could just stop using drugs? None of that helps us support the conclusions of law drawn here. In addition to that, at number 2, Sage was not living with the decedent. Well, it could also be that the decedent was not living with Sage. We just don't know. And I think that goes to the abandonment issue.
It does, Your Honor, and I see that I am out of time. I'm happy to answer, but I want to respect the court's time.
Just to follow up on that.
So we do see those things in the order. Let me find my. So if I'm understanding your question correctly, And to answer quickly, yes, it says that, and it focuses on Sage's ability to move to North Carolina and not the other way around. We also see in the record that, and I believe it says it in one of the court's findings of fact, that Matt didn't have a valid driver's license. His ability to travel was limited. So it is a one-sided relationship in that way. The trial court also found that she had registered a vehicle in North Carolina. She had registered to vote here. There are facts found in the order that the movement was to North Carolina, and then it ended. Then it stopped, and she decided not to after all.
And why did it stop?
It notes her awareness of the drug use. It does not say that he had started using again, but that is the implication. I would say on that point, this case is much like the Panhorse case from 1971. In that case, the husband said that he was justified in leaving because the wife had a health condition that limited her ability to be affectionate with him, and so he was justified in leaving. The Supreme Court said, no, a health condition is not going to be, that's not going to be a willful or cruel or affirmative cruel act that's going to justify leaving. Substance use disorder in and of itself is a health condition like that. Yes, there are behaviors that can stem from that, but the drug use in and of itself, which has been the focus of this case, it's a health condition, and it was not an offense against her, and so her awareness of it, she knowingly married him. It was an informed decision to marry him, knowing he had this condition and that these were going to be the conditions of their marriage.
Even if it's informed, you can change your mind on what the impact of that's going to be. I mean, a woman that's getting beat all through her relationship, all through her engagement, through the first years of her marriage can probably say enough's enough. And she's not going to be deemed abandoned. She knew what she was getting into, that she was marrying a jerk that beat on her. Absolutely,
and by no means am I arguing that we condone relationships where there's abuse, and by no means am I trying to minimize the effects of substance use disorder on loved ones. My point is simply that when it comes down to it, if you are not going to take on, for whatever reason, the obligations of marriage and life, are you entitled to rights in death? And that's really what this case is about, is she married Matt knowing these circumstances. She left, and I'll revert back to our briefs on the reasons why and stand on the trial court's order. But at the end of the day, she didn't act like a spouse. She did not live with him. She chose to cut off contact with him. But now she wants to come back in the picture now that he's deceased and take a part of his estate. Do you get to act as a spouse in death when you did not act as one in life?
Thank you.
And on that basis, we ask the court to affirm the trial court's order. Thank you, Your Honors.
Thank you.
Your Honor, didn't act like a spouse is not abandonment. That's the whole problem with the abandonment discussion here, and Judge Thompson hit on that when she said could be that he didn't move in with Sage, because if you don't have cohabitation, you don't know who left. You don't know whose fault it was. And this is not an attempt to expand the law of abandonment. This is a well-established law. It's in the pattern jury instructions. It's from a Supreme Court case in 1971. This court's used it in 2000, 2003, and 2020. So we know what abandonment means. The reason there are no cases that address these facts is because this isn't abandonment. This is something different that the statutes don't address. And
Well, didn't they have a regular, they did cohabit to some extent in that the findings were she would come and visit him on weekends.
It did say.
And that was their arrangement. That was their cohabiting, the way they define it. And then she stopped.
And I would argue that's not cohabitation. And in fact,
What if I live with my wife 4 months out of the year, and then I stop living with her? Is that cohabitation? I mean, because I go work in Alaska 8 months. Is that cohabitation? I mean, where do you draw the line?
And I'm just thinking, just parallel, my first 10 months on this court, I was living in Waynesville, and I was only home 2 nights a week with my wife out of 7, spend another 5 days down here in Raleigh in an apartment. Was I not cohabitating?
well, I think that was your home still, though. And you had cohabitated before. I mean, I think the issue here is they never lived together. If they had lived together in the past, it would be different. I'm out of time, but the findings of fact don't support the conclusion. In fact, they command a different response, a different answer. Thank you.
We will take this under advisement. We appreciate your arguments. Thank you.